Today we're going to engage in a HIPAA training for the compliance officer. And how we're going to approach this is I'm going to review the basics, review the nuts and bolts of HIPAA, and then also in the process of doing that, and sort of towards the latter half of the webinar, talk about what you as the compliance officer need to understand and educate the individuals who you are tasked with educating about HIPAA. What are the really important things that you need to educate them about? Okay, so let's just begin. And the reason I start with the nuts and bolts is because I have found that in the past, when I have lectured on this topic, because I have lectured on this topic nationally, both webinars and in person. And when I do the in-person lectures and I have a little bit more of an opportunity to interact with the individuals that I am teaching, I've found that there is kind of an embarrassment to admit that you don't really know the nuts and bolts. So that's why I always like to start there. And it's a good review and refresher for those of us that do. So first and foremost, the rules that control privacy on the federal level are it's a collection of laws and regulations. Okay, so the laws are the Health Insurance Portability and Accountability Act of 1996, that's what we know as HIPAA, and the HITECH Act, Health Information Technology for Economic and Clinical Health Act of 2009. These two combined laws thereafter resulted in 3 sets of rules: the privacy rule, the security rule, and the breach notification rule. These 3 separate rules are where you're going to find most of your significant guidance as to how to implement HIPAA in your practice and in your facility. And these rules pretty much existed as you see them here until 2013. Okay, so before we get to the changes that happened in 2013, the HIPAA Act of 1996, this was essentially passed by Congress in order to require the Department of Health and Human Services to develop national rules for the protection of electronic healthcare information. Okay, so electronic healthcare information was becoming more popular. People communicating about healthcare and patients electronically was something that was a very new and novel development, and the government felt that they really needed to get on top of doing something about it and protecting privacy and security at the outset of this development in medical practice. Okay, so this law was passed by Congress, and the federal government mandated that every state adopt these federal protections. So a lot of times when I'm working in other states or I'm lecturing in other states, I always advise to check and make sure with local counsel that you do not have more restrictive state laws for privacy and security, because if you have more restrictive state laws, then you need to make sure that you're compliant with the more restrictive state laws. However, most states do elect to mirror HIPAA, so if you are compliant with HIPAA, you're compliant with your state laws. That's the case for us here in New Jersey. If you are compliant with HIPAA in New Jersey, you are also compliant with New Jersey privacy laws. They essentially mirror HIPAA. For my clients in New York, there are a couple more restrictive privacy regulations that I do need to make sure they're aware of. Okay, and then HITECH Act, this was in 2009. This was actually part of the American Recovery and Reinvestment Act, or the Affordable Care Act, and this was really part and parcel of the law that was intended to promote adoption of meaningful use of electronic medical records. So essentially, the government said, okay, well, now we're telling everybody they have to adopt electronic medical records to a certain extent. So how are we going to protect the privacy and security of these medical records? And that was the HITECH portion of this act. So it really addresses and strengthens penalties for HIPAA violations and includes some very specific protections for electronic health information. Okay, so at their most basic, the privacy rule, this rule establishes the set of national standards for the protection of health information. The security rule establishes the set of national standards for the protection of health information that is electronically stored or transmitted. One of the biggest mistakes that my clients make is thinking that because they do not utilize electronic medical records and they do not utilize email and they do not ever transmit any medical records or medical information electronically, that they are not subject to HIPAA. And this is not the case, and this is exactly what I point to advise my clients that this is not the case. They may be exempt from many provisions of the security rule, but you still have the privacy rule that you have to abide by. Okay, then the breach notification rule, that is essentially what establishes the set of national notification requirements if your covered entity discovers that there has been a breach of unsecured protected health information. Okay, so a few moments ago, I said that all of this was pretty standard and pretty status quo until 2013. So what happened in 2013? In 2013, the government decided that the laws needed to be updated, revised, and streamlined to really recognize what was going on in the modern and contemporary world of electronic medical records and the utilization of electronic communication in healthcare. So in the process of updating and refining the privacy, security, enforcement, and breach notification rules, they decided not only are we going to update them, but we're going to combine them, and we're going to call it the final omnibus rule. So in 2013, the privacy, security, and breach notification rules, these were amended and they were combined, and now they are known as one body of document called the HIPAA Privacy, Security, Enforcement, and Breach Notification Final Omnibus Rule. Everyone I know simply calls it HIPAA Omnibus or the HIPAA Omnibus Rule. So anytime you hear anybody referring to HIPAA, you want to make sure that they're dealing with the Omnibus Rule or HIPAA post-2013. Okay, so what are some of these changes that we've encountered under the Omnibus Rule? This is still something very critical that I find is necessary to educate most compliance officers about because it's unfortunately some of the practices that I go into to assist, I find that the compliance officers, and it's through no fault of their own, they're not able to access resources such as this webinar or updated articles or a practice council or something like that. They don't know that if they're utilizing policies and procedures that are pre-2013, that what they're using is very likely to be out of date. So I do like to go over some of these changes. Some of the most significant changes include changes to the Notice of Privacy Practices. So your Notice of Privacy Practices, that's the document that you're going to have posted somewhere in your office. You hand out to all of your patients to make sure they know what their rights and responsibilities are with regard to their medical information. Okay, so there are some new explanatory statements required to be in that document. For example, they cover sale of PHI, marketing use of PHI, and research use. And for those that don't know, PHI is shorthand for protected health information. Okay, and these changes must have been incorporated into your Notice of Privacy Practices on or before September 23rd of 2013. This is still very much relevant, and it's still very much worth bringing up as far as I am concerned, because I still walk into practices, quite frankly, as either the attorney or a patient. I walk into practices and I see notices of privacy practices that are either dated, 2012 or earlier, or they don't have a date on them at all. And it is required that you do have to have an effective date on your Notice of Privacy Practices. So if you are currently looking at a Notice of Privacy Practices that either does not have a date on it or it's dated prior to September of 2013, it is out of date. You must update it. additional changes under the omnibus rule. The definition of a business associate has changed, okay? A business associate, for those who don't know, is anyone that you contract with to provide services to your covered entity. Okay, so this is not employees, not owners, anyone you contract with to provide services to your covered entity who is going to have more than incidental access to PHI. All right, so now the definition of business associate has changed in 2013, and there is a new category of a subcontractor business associate. And that essentially handles how do you handle if your contractor utilizes a subcontractor to carry out services for you. Okay, so just some of the technicalities here. Grandfathered business associate agreements could remain in place at that point until September 2014. All other business associate agreements needed to be revised on or before that magic date, September 23rd of 2013. And any grandfathered business associate agreement is one that was in place prior to January of 2013. I go through all of this because I have had people say to me, oh, but mine's grandfathered, so I don't have to replace it. No, that's not the case. At this point in time, as we sit, if you have any business associate addendums that are older than September 23rd of 2013, they do need to be updated. And the grandfathering exception expired in September of 2014. Okay, so additional changes. Of course, we have enhanced penalties for violations. Anytime the government is going to go through the trouble of rewriting and modifying a law and going through the voting process, they're definitely going to enhance penalties. You know, a penalty that could have been disastrous to a medical practice 10 or 15 years ago could be, you know, not even discourage the violation now. So, of course, the penalties and the violations were assessed and they were updated to make them more effective for the current economic climate. A breach was redefined. Prior to 2013, you assumed that any security incident was not a breach and you had to prove it was a breach. Now you assume everything's a breach and you have to prove it's not a breach. And we'll go over that a little bit more specifically. Okay, so the previously used harm analysis has been replaced with a 4-factor risk assessment. And now health plans are prohibited from using or disclosing genetic information for underwriting purposes. And that is the GINA, or the Genetic Information Non-Discrimination Act. This is the only time it's going to be mentioned in the lecture, because I typically do not have a lot of individuals from health plans in my audience. But if anyone wants a little more information about that, please don't hesitate to email, and Compliance IQ will get you in touch with me. And I can point you to some resources for that. Okay, and most importantly now, we have separate authorizations required for different kinds of PHI. One of the big problems also that my clients still have is that they're not properly separating their authorizations, and their authorizations do not have all of the appropriate notifications and information in them. If you're using an authorization that's literally, hi, I, patient, give you, doctor, the right to send my records to, and there's an address and a signature line, that is not a sufficient authorization. Okay, sufficient authorizations now at least take up an entire 8.5 by 11 page with mandatory notifications to that patient that must be included in the authorization. All right, so a business associate versus a covered entity. I touched on this a little bit when I was talking about the changes to business associate regulations, but I do like to just put it out here front and center. What is a business associate? What is a covered entity? Okay, covered entity is any provider that transmits any information in electronic form a health plan or a healthcare clearinghouse. Now, you will recall that I said earlier that a huge mistake my clients make is they think that if they're not transmitting anything in electronic form, they're not subject to HIPAA. Okay, so now you're looking at this and saying, but Gina, it says right there that if you don't transmit information in electronic form, you're not a covered entity. To me, this is a very simplistic definition of covered entity. And if you look more closely at the regulations, case in point being the completely separate existence of a privacy section as opposed to a security section, and the differentiation between the two being that the security section covers electronic transmission and the privacy section simply covers medical records. To me, that alone is evidence enough that the government intends this to apply to all health information, and that all providers, physicians and providers practices are covered entities that are subject to HIPAA. Okay, so who is a business associate? Again, it's any person or entity other than a member of the covered entity's workforce who performs services on behalf of the covered entity that involves access to protected health information. A couple of examples, and who is not a business associate? Any person who provides services that does not involve access to protected health information. So two really good examples. If you have shredder boxes in your office and you are throwing patient information in them, the shredding company that picks up and empties those boxes and takes that information to be shredded and disposed of, they are a business associate. You should have a business associate agreement with them. Who is not a business associate? Your nighttime cleaning crew, someone who comes into your office in the evenings to vacuum, sweep, Windex, things like that, do just the general dusting and the upkeep, clean the bathrooms. They're not going to have any access to protected health information. So they are not a business associate. The only exception to that would be I had one client one time ask me if their nighttime cleaning crew was a business associate, and I said no. And then 2 months later, it comes out in conversation that their nighttime cleaning crew is filing patient records for them. That is not a cleaning crew, that's a filing service. That is a secretarial service. So, to me, that is a very specific situation. And just as far as I see a question over here, and I know we usually hold questions till the end, but I think it's relevant to now. What about payers? The payers are not considered business associates. The payers have a contract with the participants that allows you to share the participants' medical records with them for payment and healthcare operations. So payers are not considered business associates. Okay, so what are your basic requirements under HIPAA? Basic requirements include you have a notice of privacy practices. Okay, you need to know when patient authorization is required and not required to use or disclose protected health information. You must have a privacy officer. You must know how patients are permitted to have access to their own protected health information. Patients are permitted to an accounting of disclosures, and patients are permitted to amend their medical records. And we're going to go through each one of these in more detail. Right now, I just kind of want you to, on this slide, focus on the overview and the big picture. Okay, number 5, you have to have administrative, technical, and physical safeguards in place, and you have to have all your agreements in place with your business associates. So first and foremost, let's take a look at the notice of privacy practices in a little bit more depth. Okay, all covered entities must have a written notice of privacy practices, and it must explain in detail to the patient how the covered entity may use or disclose the patient's PHI, the patient's rights as to his, her, or their PHI, and the covered entity's obligations as to the patient's PHI. And this is not just one sentence about how I can use the PHI, one sentence about your rights to your PHI, and one sentence as to obligations. I have been trying since 2013, when I extensively worked on a complete overhaul of my privacy manual that I utilize for my clients and the corresponding documentation. I have been trying since then to get my recommended notice of privacy practices to be under 3 sides of an 8.5 by 11 piece of paper, because in my opinion, that's what it takes to get all of the required notifications in there. So, one thing I tell my clients when I come in is, and I do initial inspections, if you're showing me a notice of privacy practices that's 1 page or 1 side of a page or a half a page, chances are there are significant elements that are missing. And that's something that you should certainly think about having reviewed. Okay, so for you, as the compliance officer, okay, we have this great notice of privacy practices. I've checked that it's up to date. What do I do with it? Okay, there's a lot of confusion in this area as well. A notice of privacy practices, first and foremost, must be provided to each patient on their first visit. Okay, so what that means is that you have a brand new patient that comes in, along with any of their other patient notifications, financial forms, anything else you would like them, histories, anything else you would like them to fill out and sign. You will also be handing them a paper copy of your notice of privacy practices for them to keep. In exchange, you are going to be asking them to sign an acknowledgement that they received a notice of privacy practices. They do not have to sign in order to receive services, but if they refuse to sign, a note should be made in the patient chart that the patient was provided a copy, the date and time upon which they were provided the copy, and that he or she refused to sign. Okay, it must also be posted in a covered entity's office in an area where patients have access. I always recommend the waiting room. That's the best practices as far as I'm concerned. And it must be included on the covered entity's website if a website is maintained. One of the #1 ways, in my opinion, that the Office of Civil Rights is selecting practices to randomly audit for HIPAA compliance is they're basically just looking at people's websites. And if there's no notice of privacy practices on the website, or if the notice of privacy practices on the website is deficient, they're flagging them for a random audit. Okay, so after you provide it to them the first time, you never have to give it to them again unless they ask for it. It doesn't have to be provided every year. It doesn't have to be provided, if they come in to see a different doctor in the practice. It doesn't have to be provided if it changes or it's updated. After you give it to them the first time, it only has to be given to them if they request a copy. Okay? 2 important notes, all right? If a patient does request a copy, it has to be provided to them in hard copy. You cannot say to them, go to our website, it's there. You can print it out from our website. So what I recommend to my clients is always you're not going to have people ask for this a lot. It's generally the older patient population that may not be as technologically savvy, or perhaps even, a patient who is anticipating a move or something like that and is concerned that they're going to need to know how to get their records. Or quite frankly, sometimes it's patients who are contemplating litigation, perhaps for an injury that they're being treated by your practice for, and they need to know how they can get their records. Okay, so people do ask. It doesn't happen very often though. So my general recommendation to my clients is just keep like 4 or 5 hard copies of your notice of privacy practices that are not allocated for new patients. These are just 4 or 5 extra copies at your reception desk. So if somebody does ask, they're readily available and your receptionist can simply hand it to them. If someone does ask, you don't have to have them sign an acknowledgement if they received it. You simply just hand it to them and it's a day, okay? And again, like I said earlier, your notice of privacy practices must include an effective date. So if you have a document that has no effective date or it's prior to that September 23rd, 2013 date, then it is out of date, and I highly recommend you have it reviewed. And again, like I said before, when you update your notice of privacy practices, you do not have to redistribute it to everyone, because the idea is it's posted in the office, it's going to be posted on the website, it's going to reflect an updated effective date, and if anybody wants a copy, when they see that, they can ask for a copy and they have to be provided a copy. Okay, so uses and disclosures of PHI. We're going to move off of notice of privacy practices now. And what happens when a patient wants to use or disclose their PHI somewhere? Under the omnibus rule, you now have to have 3 separate authorizations. Most of the practices I work with, all they ever going to need is a general authorization for use and disclosure. This basically applies to everything except for psychotherapy notes or use or disclosure for marketing purposes. Okay, so if it's not for psychotherapy notes and it's not for marketing purposes, you're always going to use your general authorization for use and disclosure. And that's really why about 95% of my practices, all they ever need is a general authorization for use and disclosure. If you are in the type of practice where psychotherapy is performed, any kind of therapy or counseling is performed, and there is a segregated part of the patient record that qualifies as psychotherapy notes, they do always have to be segregated from the rest of the medical record in the medical record, and as such, they do require a separate and specific authorization. I get the question a lot, what is a psychotherapy note? How is that different from the rest of the medical record? And the most basic example that I usually give is this. The medical record says this, and please forgive me if there are any clinicians on the line, and this is not clinically accurate. I don't profess that it's clinically accurate. It's just purely for illustrative purposes. Okay, so the medical record would be, this patient suffers from depression. This patient is prescribed talk therapy and medication for their depression. This patient sees me every month. This patient is showing improvement. And that's the medical record. The psychotherapy notes are, this patient suffers from depression resulting from trauma and abuse when they were a child, and this is what that trauma and abuse consisted of. This is exactly what happened to them. These are my notes. Okay? So that's really the difference. And those types of psychotherapy notes they're subject to a higher level of protection, and they require a specific authorization. I have seen some clients trying to do the checkbox method. I want my general record released. I want my psychotherapy notes released. Doesn't work that way. The regulations specifically say that they must be a completely separate and specific authorization. And then finally, authorization for use and disclosure for marketing purposes. This is basically, me or someone who contracts with my practice may communicate with you to let you know about this great product that they can offer you. It's not necessarily a clinical product. It's not necessarily a product I can prescribe, but it's just something I love that I find really helps my patients. You have to have your patient's permission, okay, to allow communications with them for that purpose, even if it's from you and your practice. This does specifically exclude things like refill reminders, as long as the practice isn't getting any kind of remuneration, for making those refill reminders. Certain other communications about treatment and healthcare operations purposes, if there's no remuneration to the practice for exchange for making such communications, that's fine. What we're really talking about here is, and this is kind of a really extreme example, but, a surgeon, a knee surgeon who says, okay, now that I've replaced your knee, it's also good for you to, get a little bit physically more fit, reduce the weight on your knees. Oh, and by the way, here's a product I love that can help you. That's not a prescribed product. That's not something that really has to do with their clinical treatment, but it could really be a product that, you know, the doctor is encouraging that they purchase. So you really, especially if the doctor is making any kind of a profit or remuneration off of the sale of that product, you do have to have a separate authorization for that. Okay. Now that we know what 3 separate authorizations we have to have, any authorization you're using, one of the actual requirements is it must be written in plain language that the typical patient can read and understand. Okay, so it has to be kept very basic. And here's what it actually has to contain. A meaningful description of the information to be used or disclosed. All right, meaningful can be my entire medical record. That's meaningful. But there has to be a description, okay? Name or other specific identification of the person or entity authorized to make the requested use or disclosure. Name or specific identification of the person or entity to whom the disclosure will be made. A description of the purpose, and at the request of the individual, sign. Okay, they can say it's for litigation. They can say it's to send to my new doctor. They can say, you know, I want my family member who's a provider, a clinician, to take a look at it. Anything. At the request of the individual is also fine. They don't have to tell you. They could just say it's because I want it, and that's fine. There must be an expiration date or event. There is no parameter that says it expires within a certain amount of period. If there is no expiration date or event, but there must be an expiration date or event. What is an expiration date or event? If it's the individual who is seeking their medical record for purposes of litigation, the expiration event will typically be listed as the end of litigation. That could be years, and that's valid. And then it must also have the signature of the requesting individual. The signature does not need to be original. It does not need to be notarized. It does not need to be witnessed. What I do always advise my clients, if you are getting a faxed or emailed authorization for use and disclosure, it never hurts to just pick up the phone really quickly, especially if you're not expecting it and you haven't already discussed it with the patient in person. It never hurts to pick up the phone and call the patient and say, hi, I received your authorization. I just want to make sure that it was really you that sent it in. And then if they confirm, then you just make a little note in the chart that you called to confirm it was them. I find this avoids problems that I have seen, particularly with regard to individuals who are divorced or separated or something like that. A lot of times it happens even if there's, you know, suspicion of infidelity. Spouses or ex-spouses or, you know, that third person getting in the middle of the spouses will attempt to get someone else's medical record, you know, to use it as a custody weapon or something like that. So you want to just be very careful, especially if you get a faxed or an emailed record request and you're really not expecting it, then you want to just give the patient a quick call and make sure it was them. All right, there are some additional required statements that have to be on an authorization. You must have a statement on there advising the patient that they do have the right to revoke the authorization in writing and any exceptions to this right. That whether or not your facility has an ability or inability to condition treatment, payment, enrollment, eligibility, et cetera, on their willingness to sign an authorization. And if you do have, most practices do not have an ability to condition treatment on the signing of an authorization. But in some very specific situations, this does apply. So if it does apply, you must list the consequences of refusal to sign when there is a lawful ability to condition any of these items on a signed authorization. Okay, and then you also have to warn the patient, once we disclose your information to the person we're disclosing it to, we no longer have control over it. Okay, it could be subject to redisclosure. It is your responsibility to make sure that whoever you are asking us to disclose this to is going to keep it confidential in the same manner which we would. Okay, so what you need to do is make sure that you have all of these statements on your authorization. So that's why what I said earlier, you know, a complete authorization, it's really not going to be just a half a page or something like that. It's a pretty full page, not a lot of white space. All right, written authorization is required when the disclosure is for any reason other than treatment, payment, healthcare operations, or when the disclosure is not one that's otherwise permitted under HIPAA. Oral authorization is sufficient in some scenarios. Informal permission, this is also called the opportunity to agree or object. It is sufficient to allow disclosures for facility directories of patient contact information, notification or disclosure to a family member or friend or relative to the extent that person's involved in the patient care, and notification to a school regarding a student's immunization records. And that was actually a big change that was a relief to a lot of people under the omnibus rule. Prior to the omnibus rule, requests to send immunization records to schools had to be made in writing. And now they basically said, look, you can just tell your doctor where to send it. It doesn't have to be in writing. And it alleviated a lot of paperwork for everybody. Okay, so when is an authorization not required? There are specific scenarios. Essentially, the catch-all when it's required by law to disclose, you do not need an authorization. This is the big example of this is the gunshot wound coming into the ER. You know, that's typically evidence of a crime. So that does have to be reported to the police. Okay, public health activities, anything that needs to involve the CDC, OSHA, or the FDA. Victims of abuse, neglect, or domestic violence, there are various levels of reporting requirements with regard to these victims in order to protect them. Health oversight activities, if you are in a practice or a facility or a hospital that is accredited by the Joint Commission, licensed by the Department of Health and Senior Services, you know, even controlled by state board of, you know, your various state boards that control licensure. If they're coming in to do any kind of health oversight activities, you typically do not need a patient authorization for them to take a look at your patient's PHI and see what's going on. Okay, judicial and administrative proceedings, but the important thing to remember here is only if there is a court order. Subpoenas are not sufficient without more in the vast majority of states, particularly in the state of New Jersey. I could print out 15 subpoenas right now for various items and send them out to different people. And if any of them are for medical records, they are not worth the paper they are written on unless they are accompanied by a signed authorization, which is why a lot of times when people are seeking medical records, they'll, you know, make a motion to the court or file some type of preliminary court action seeking a court order for those records if the other party doesn't consent and give their authorization. Okay, so one of the number one things I tell my clients is if you have something from a lawyer asking for medical records, if they, you know, if they don't have a clear signed authorization by your patient, they don't get anything. You have to simply respond and say, thank you, I'd really love to help, but my hands are tied. All right, law enforcement purposes, if law enforcement is looking for a suspect or a victim, etc. And then decedents, funeral directors and medical examiners can also receive information without authorization. And that's actually, just as an aside, you do still have rights and privacy rights in your PHI after you're deceased, and for at least 50 years after you're deceased. A lot of people don't realize that. Okay, when is authorization not required? Some more examples. Organ donation, research, credible threats of a serious threat to health or safety, essential government functions, if it's the military, if it's an inmate, etc., and then workers' compensation. Okay, so all officers, all practices should have one individual who's designated a privacy officer. This could be all of you that are on the call with me here today, on the webinar here with me today. And it is your responsibility to make sure that the practice meets all requirements of HIPAA. If the compliance officer and the privacy officer are one and the same, then you can apply everything I'm saying now to you in your position If you do work in conjunction with a privacy officer, it's your responsibility to make sure that the privacy officer is performing these tasks. These tasks are delegated to them, and they are performing them competently. They do have to perform a regular internal compliance risk assessment and conduct regular staff training on the requirements and implementation of HIPAA. By regular, no less frequently than annually. Okay? Anybody upon hire should typically be trained within the first 60 days of hire, and then everybody should be trained annually thereafter. What I typically advise my clients to do is train everybody when they're hired, and then also have a regular annual training for everybody else. Like, Christmas week is slow every year, so we're going to do all our annual trainings at lunchtime on Christmas week or something like that. Okay, and that kind of keeps it on schedule. And then, of course, keep evidence that these trainings are happening, keep attendance lists, who attended, who participated. Regular internal compliance risk assessment reviews, these are a little bit more difficult because you do have to do an annual risk assessment for not only your privacy safeguards, but also your security safeguards. So I do recommend that this is something that you enlist the assistance of your information technology people or your information technology company. And this is actually, there are companies out there that will help you do an annual compliance risk assessment online, and they are wonderful. I actually have one that I've vetted quite extensively that I recommend to all of my clients for their annual risk assessments. And these risk assessments and the trainings are probably like the top two things that the government is looking for if they do come in and audit your practice, either as a result of a complaint that you violated HIPAA, or if you get flagged for a random audit. Okay, so the risk assessment, as I said, it must be done annually. You have to review all of the administrative, technical, and physical safeguards. You must keep a log of the review. Okay, and you must know what elements of administrative, technical, and physical safeguards are required and what are considered what is simply addressable. Anything that's required has to be in place. The required elements are a lot more minimal than people would think when they actually get down into it. Anything that's addressable must be addressed in your assessment, but does not necessarily have to be in place. All right, so some examples of administrative safeguards, your security processes, you have to have a security official, information access. If you're, somebody does not need the information to do their job, there should be measures in place to prevent and trace access. Training, like I said, annual training for all workforce members, and then evaluation. You have to periodically be evaluating all of this and making sure that it's in place. Technical safeguards, again, this is where even my clients, I advise them that they must get their IT services involved. This is something that is, beyond the scope of an attorney unless they're also an IT specialist. All right, access control, passwords and logins, making sure all of your hardware and your software is up to snuff. Making sure that PHI is not impermissibly altered or destroyed, and transmission security. And what a lot of people don't know is encryption is the best way to do this, and I highly recommend encryption, but it's not specifically required by the law. You can also transmit things password protected. The only caveat with that is do not send the password by the same modality that you're sending the password protected item. So if you're emailing out a password protected document, call the recipient and give them the password. Text the password. Don't email the document and then send a following email with the password. Because if the email is compromised, it's compromised, and now they have both. Okay, physical safeguards, these are the easy ones. Door locks, access cards, alarm systems. You don't allow unauthorized persons to be wandering around the file room. Laptops and desktops are locked to the surface. You have policies regarding the use of laptops off-site, and policies and procedures for disposal of old technology. Essentially, anything has to be wiped and rendered completely ineffective. All right, and then finally, we're going to talk about has there been a breach? Okay, so a covered entity must first conduct an assessment to determine if a question event is a breach, and they have to consider the nature and extent of the PHI involved, and the likelihood of identification. This is your four-prong test, okay? So something happened, we're calling it a breach until we can prove it's not. And in order to prove it's not, you have to consider the nature and extent of the PHI involved, and the likelihood of identification, the unauthorized person or persons who received or accessed the PHI, whether it was actually acquired or viewed, and the extent to which the risk has been mitigated. This is a really critical process, and something I've also found in my travels around the country educating on this topic is that people really are over-reporting things as HIPAA breaches that are not breaches. And as much as, of course, I would encourage anyone, you must comply and you must report a breach in order to remain compliant with the law, you also don't want to over-report because you could potentially flag yourself for an inspection that you're not deserving of, or an audit that you're really not deserving of. Okay, so if your covered entity determines that the incident is in fact a breach, there must be notifications, all right? All breaches, notifications to the individuals affected within 60 days of discovery by first-class mail. If you have insufficient contact information for 10 or more of those people, you have to place a notice on your website or in a local newspaper with a toll-free number where individuals can call to find out if they were affected. And then this number must remain active for a minimum of 90 days. Okay, so this right here, I tell everybody, this is why you always want to have an updated address for all of your patients. Don't allow them to leave it blank because if you don't ever want to have to put a breach on your website because you don't have good addresses for 10 people that were affected. Okay, fewer than 500 individuals affected, notification to the secretary is required, and this is the secretary of the government entity, within 60 days of the end of the calendar year in which the breach is discovered. Okay, so basically, if fewer than 500 individuals are affected, let's say you have 2 or 3 breaches over the course of the year, you can save them all up and let the send your notice to the secretary in January. All right, and then if you have more than 500 individuals affected, the secretary needs to know immediately, but in any event, no later than 60 days, and notification to the media is required. All right, business associate agreements. I have a little bit more information for you about this here, but I think we've really covered it very extensively, and I do want to make sure I at least leave 5 minutes for question and answer at the end. So you do have this information here. The agreement has to establish permissible uses and disclosures of the PHI by the business associate. It does have to bind the business associate not to further disclose the PHI unless it's to some extent permitted by law. And the business associate has to implement the same HIPAA security rules safeguards as the covered entity. The best example of that is me. I am an attorney. I have a law firm. Probably about 70% of my clients are medical practices and providers. I have to be HIPAA compliant in my office, and I'm very adamant about being HIPAA compliant in my office. Okay, and then the business associate does have to be required to disclose PHI as needed to the covered entity if there are any disclosure requests. As we said, there has to be a written agreement, and there also now, under the omnibus rule, needs to be a written agreement between the business associate and any subcontractors that business associate might be utilizing to provide services to the covered entity. And you can see here really all of the same things apply, because as you can see here, I basically said the written agreement between the covered entity and the business associate, or between the business associate and their subcontractor, has to require all of these things. Okay, the business associate abides by the privacy rule, makes records available, return or destroys data, and the covered entity is authorized to immediately terminate any agreements if the business associate or a subcontractor violates any terms. All right, again, who is a business associate subcontractor? We've definitely mentioned this several times already in the last hour, but just for purposes of extreme clarity, a business associate, the same analysis to determine if a person's a business associate applies to determine if they're a business associate subcontractor. That being, any person or entity other than a member of the business associates workforce who performs services on behalf of a business associate that involves access to PHI. Okay, so the business associate should be required within the terms of their business associate agreement to have similarly written agreements with any subcontractor they utilize, and these agreements should have all of the same obligations of the main business associate agreement. All right, so we're going to finish up now just touching a little bit on the enforcement actions that have been going on. The Federal Office for Civil Rights, you've heard me refer to that already as OCR. This is the office that has the duty and the responsibility to oversee HIPAA and HIPAA compliance. Okay, and they did begin a preliminary pilot program for random compliance in 2015. Essentially, the government said, hey, OCR, we have this great law here. You're doing absolutely nothing to enforce it unless people complain. And the random audit program was born. All right, so a lot of the things that we talked about today are what OCR is looking for when they're performing a random audit. Okay, do you have a notice of privacy practices? Is it complete? Is it posted? What are patients' rights? Okay, is everything that's supposed to be included in that notice of privacy practices properly included? What are administrative requirements for security? Are there proper authorizations for use and disclosure being utilized? And are there proper administrative, physical, and technical safeguards in place? Okay, so OCR was on track to begin its second round of HIPAA audits in early 2016. They did start them a little bit late. They started them late 2016, early 2017, but this program is still ongoing. It hasn't been exploding as fast as we anticipated that it would, but it is important to just have it on your radar, know that it can happen, and if you do have someone complain to OCR about your HIPAA practices, it absolutely will happen. Okay, and this is just, I like this graphic. It shows the complaints received by calendar year. And you can see just from 2015 to 2018, an increase of almost 9,000 complaints a year. And you can see that link below if you wanted to go get more historical data or anything like that. This is where I get this from. It's right from hhs.gov, the Health and Human Services federal government website. And there's a whole section with really great information about HIPAA. And, you know, I like to include this because I just like to remind everybody that in this day and age, it is so easy to complain. You just go on the internet for free and you click a button and you can file a complaint. Okay, and then total cases and sources. Complaints, you'll see, like I said here, that first column is complaints. That's where most of the sources are coming from. Compliance reviews, significantly lower, but they're out there, okay? And last one here is the top 5 issues investigated with corrective actions by calendar year. You can see number 1, for 3 out of the last 4 years, impermissible uses and disclosures, and then number 2, safeguards, 3 out of the last 4 years. Okay, so really the uses and disclosures, making sure you have that down pat and making sure that you have your safeguards and your administrative safeguards and your technical safeguards in place. These are all easy to get current with, but also easy to forget about.